Karunji. I'll be presiding over the case of Salvatori Abuki and Richard Abuga versus Attorney General. It's a constitutional court case at Kampala, Republic of Uganda. Quorum, we have Manyindo, DCJ, GM Ukelo, JA Bahigeine, Tabaro J, and Igonda Ntende J. It's a constitutional case of number 2, 1997. The judgment, I'll proceed with the judgment of Judge Manyindo, the Deputy Chief Justice. The petitioner, Salvatori Abuki, outlining the brief facts of the case. Salvatori Abuki and one Richard Abuga brought this petition challenging the convictions under the Witchcraft Act. They were tried separately in Grade 2 Magistrates Court of Aduku in Lila District. Salvatori was judged in one court with practicing witchcraft on Albertina Agol. We have Okai Alessandro and David Ongola, contrary to Section 3, Subsection 3 of the Act. He pleaded guilty, was convicted, and sentenced to 22 months imprisonment. In addition, he was banished from his home for 10 years after serving the sentence of imprisonment. Clearly, he should have been charged in 3 separate counts, one for each of the complainants. Richard Abuga was convicted of being in possession of articles used for witchcraft, which is also contrary to Section 5, Subsection 1 of the Act. In this first count, and with practicing witchcraft contrary to Section 3, Subsection 3 of the Act in the second count. He was sentenced to 36 months imprisonment on the first count and 24 months imprisonment on the second count. The sentences were to run concurrently, and exclusion order for 10 years was also made against him. Their appeals to the Chief Magistrate's Court failed. The two men then brought this petition for declarations through the Constitutional Court. Number 1, that the Witchcraft Act Cap 108 laws. The two men brought this petition for declarations, and one was that the Witchcraft Act Cap 108 laws of Uganda, and 2, the conviction sentences and exclusion orders thereof are inconsistent with the Constitution. Articles 21 clause 1, Article 28 clause 1, and Article 28 clause 12, Article 24, Article 44, with Article 26 and 29.1 to B, C, and 29.2 of the Constitution of the Republic of Uganda, and for the grant of an order quashing the convictions, setting aside the sentences and exclusion orders, and setting the petitioners free, or refer the matter to the High Court to investigate and determine an appropriate redress. Article 21, Clause 1 states that all persons are equal before the law, regardless of their standing in society. Article 24 prohibits the subjection of a person to any form of torture, cruel, inhuman, or degrading treatment or punishment. Under Article 26, every person has a right to own property which must not be taken away from him or her, except in specified circumstances, and even then after that person has been fairly, adequately compensated for their loss. Article 28, Clause 1 guarantees a right to fair hearing before courts and other tribunals established by the law. See Article 28, Clause 12 provides that, except for the contempt of court and other tribunals established by the law, no person or no any offense, unless the offense is defined and the penalty for it is prescribed by law. Under Article 29, Clause 1, Paragraph B and C, that provides for freedom of thought, conscience and belief, and religion is guaranteed. While under Article 29, Clause 2, every Ugandan has the right to reside and settle anywhere in Uganda, to have a passport or travel document and travel in and out of Uganda. Finally, Article 44 prohibits derogation from particular human rights and freedoms, to wit, Clause A, freedom from torture, cruel, inhuman, or degrading treatment or punishment. Furthermore, we are seeing in B, freedom from slavery or servitude, and we are seeing also in Article 25, Clause 1, C, the right to fair hearing, and D, the right to an order of habeas corpus. Article 23, Clause A, The petition, which was accompanied by an affidavit sworn in by petitioner on 31st January 1997, was amended with leave of court. The grounds of the petition state as follows. 1. Your petitioners are persons having interest in or affected by the following matters being consistent with the Constitution, whereby your petitioners are aggrieved. A. That the Witchcraft Act, Cap 108, Volume 4, Laws of Uganda is inconsistent with the Constitution for it. Paragraph 1 creates the offense of practicing witchcraft in Section 3, subsection 3, and possession of any articles used in witchcraft. That is Section 5, Clause 1. We are seeing also, furthermore, it provides for banishment of a convict from his home area for a period of 10 years after serving a custodial sentence. And B, that magistrate, grade 2 of a Abuki magistrate court, in convicting the petitioners under the Witchcraft Act, sentencing them and excluding the petitioners from their home area after serving the sentence, and the chief magistrate in dismissing their appeals and confirming the said conviction, sentences and exclusion orders under the authority of Witchcraft Act were both in contravention of the Constitution. Whereof your petitioners pray that court may grant a declaration that the Witchcraft Act, Cap 108, Laws of Uganda, and the convictions, sentences, and exclusion orders thereof are inconsistent with the Constitution, Articles 21, Clause 1, 28, Clause 1, 28, Clause 12, Article 24, Article 44, Article 26, Article 29, 1, B, and Clause C. And we are seeing that also there is Article 29, Clause 2. B, grant an order questioning the convictions, setting aside the sentences and exclusion orders, and setting the petitioners free, or refer the matter to High Court to investigate and determine an appropriate redress. The respondent's answer to the petition was A, that the Witchcraft Act is not inconsistent with the provisions of the Constitution, that is in Clause B, that the exclusion orders and penalties for prescribed offences and thereof do not contravene Articles 29, Clause 2, and 26, Clause 2 of the Constitution of the Republic of Uganda. We are saying that petitioners have not been deprived of their property without compensation and contemplated under Article 28, Clause 12 of the Constitution, and D, that in any case the petitioners had a right of access to court by way of an appeal against conviction or sentence of both, and or should not have come to a constitutional court. Sadly, Richard Abuga passed away at Mactions Bay Prison, Resila, a day after the hearing of the petition had started. Accordingly, his petition abated under Rule 15 of the Modifications of the Fundamental Rights and Economic Freedoms. Those are enforcement procedures, rules that are under the 1992 directions and the 1996 legal notice, number 1 of 1996. Counsel for petitioner framed the following issues which were accepted by counsel for the respondent. 1. Whether the Witchcraft Act, and in particular provision for exclusion orders in Section 7, infringes or inconsistent with Articles 24, Article 26, Clause 2, Article 29, Clause 2, and Article 44 of the Constitution. 2. If the answer to Clause 1 is no, can the conviction of the appellant be maintained in view of the provision of Article 28, Clause 12 of the Constitution. 3. Whether the petitioner was afforded a fair trial or hearing under Article 28(1) of the Constitution. Whether the Witchcraft Act infringes Article 21 of the Constitution, which article guarantees to all persons equality and freedom from discrimination. Mr. Emoru, who presented the petitioner's case, agreed that the offense of witchcraft is not defined in the Witchcraft Act, which contravenes Article 28, 12 of the Constitution. According to him, only acts of witchcraft are spelled out in Section 3 of the Act, which states that any person who directly or indirectly threatens another with death by witchcraft by any other supernatural means shall be guilty of an offense, and on conviction shall be liable to imprisonment for life. Any person who directly or indirectly threatens or causes disease of any physical harm to another, to cause a disease or any livestock or harm to any property whatsoever sought of any other by witchcraft or by other supernatural means shall be guilty of an offense, and on conviction shall be liable to imprisonment for a period not exceeding 10 years. In Mr. Emoru's view, Section 3 quoted above is vague. It does not create an offense. It follows that the petitioner was tried on an undefined offense, which means that he was not given a fair trial. We are saying that this convicted and this contravened with Article 28(1) and Article 28 clause 12 of the Constitution. With regard to the exclusion orders, Mr. Moru contend that the provisions of the same in Section 7 of the Act is inconsistent with Articles 24 and 44 of the Constitution in punishment is inhuman, cruel and degrading punishment, as it deprives the convict of food and shelter, which are essential to life. The person concerned is made homeless and destitute, yet derogation from the enjoyment of freedom from cruel, inhumane, or degrading treatment or punishment is prohibited by Article 44 of the Constitution. It was also argued that the exclusion order would mean that the petitioner would lose control of his house and other property. It would amount to an indirect deprivation of property without compensation, which would violate Article 26 of the Constitution. A submission under ground 2, that is under clause F, we are saying of the petition of the basis of Witchcraft Act, was discriminatory in the fact that the offences therein related to men only was abandoned when it occurred to counsel for the petition that was not in the position. Also, the ground alleging violation of thought, conscience, and religion by some provisions of the Witchcraft Act was abandoned because Section 2 of the Act with witchcraft does not include, among others, bona fide spirit worship. As this court observed in Tinifunza versus Attorney General, that is the Constitutional Petition number 1 of 1996, the rules applicable to interpretation of statutes apply to construction of constitutional provisions, but that a constitution should be given a rebel constitution, unfettered with technicalities with regard to human rights and freedoms. I find the observation by Lord Diplock in Attorney General of the Gambia versus Modern Jobe, that is 1984, Privy Council that also pointed that a constitution, and in particular the part of it which protects and entrenches fundamental rights and freedoms to which all persons in state are to be entitled, is to be given generous and purposive construction. With these principles, it now turn to the issues raised in ground of this petition. They can be summarized as follows. Number 1, whether the petitioner was convicted of a defined offense carrying a prescribed sentence. 2, if the answer to 1 is in negative, whether the petition was defined a fair hearing. 3, whether the exclusion order is cruel, inhumane, and degrading punishment. 4, whether the exclusion order amounted to depriving the petitioner of his property without compensation. 5, whether the petitioner is entitled to declarations sought. Furthermore, in this state case, the charge against the petitioner was drawn as follows: statement of offense, practicing witchcraft, that is under clause section, in contradiction to section 3, subsection 3 of the Witchcraft Act, particulars of the offense. Salvatori Abuki on the 4th day of December 1995 at Abuga B, Ogonga Parish, Nambiko Sub-County, Kwanya County in Apache District, practiced witchcraft on Albatania, Agol, Okai, Alcassandro, and David Ongolo. In my view, the above charge is no different from, say, that of murder, where the indictment usually states as follows: statement of offense, murder, contrary to section 183 of the Penal Code Act of Uganda. Particulars of offense. Particulars of the offense, Salvatori Abuki on the 4th day of December 1995 at Abuga B, Ogonga Parish, Nambi Sub-County, that is Kwanya County in Apache District, practiced witchcraft on Albatania, Agol, Okai, Alessandro, and David Ongoro. In my view, the above charge is no different from, say, that of murder, where the indictment usually states as follows: statement of the offense, murder, contrary to section 183 of the Penal Code Act. Particulars of offense, on the day of 1997 4th, that is January, at Nagokolo village in district, murdered wife. For the ingredients of the offense, one has to look elsewhere. In the case of witchcraft, I'm of the opinion that section 3 has to be read together with section 6 of the Witchcraft Act. Clearly, the Constitution does recognize the fact that it is in public interest to punish criminals who have been fairly tried and found guilty by courts. People who commit crimes must not expect to be treated with kid gloves. They must expect to receive sentences that fit the offense they have committed. The sentence may be cruel, inhumane, and degrading, but they are lawful even under the Constitution. Such sentences are accepted even in greater democracies, such as the United States of America and the UK, that applies common law. They are necessary evil. That is why the framers of our Constitution retained them. I think that the real point is that Uganda of today, no one except the courts of law may punish a person in a manner that is cruel, inhumane, and degrading. The exclusion order restricted the petitioner's right under Article 29, Clause 2A to move freely throughout Uganda and to reside and settle in any part of Uganda. In my view, that right can only apply if one has not committed an offense for which there is a prescribed sentence. In the case before us, the exclusion order is part of the sentence under the Witchcraft Act. It is therefore law under Article 23 of the Constitution. I do not agree that the order deprived the petitioner of his property without compensation under Article 26, Clause 2 of the Constitution, that provides that no person may be compulsorily deprived of property or any interest in or right over property except in circumstances specified in the article, and even then fair and adequate compensation must be paid before the property is taken away. In this case, the exclusion order does not and could not take away the petitioner's property. All it does is temporarily inconvenience him in that he could not live in his house during the pendency of the order. It is a generous order in that it does not, when it could, prohibit the petitioner from living elsewhere in the village. He can have access to his food, crops, if any, through his family or friends, since the order does not, when it could prohibit communication between him and such people. The Witchcraft Act may have outlived its usefulness, but in my view, it is not inconsistent with the Constitution of the Republic of Uganda. In the result, I would not render the declaration as sought, and instead would declare that Section 2, 3, and 7 of the Witchcraft Act are not consistent with Articles 21, Clause 1, 24, 26, Article 28, Article 28, and Article 29 of the Constitution of the Republic of Uganda. I would therefore dismiss the petition and order that each party meets its own course of the petition, but in accordance with the majority opinion, it is ordered that the following declarations shall issue. The sections interpreting witchcraft, that is Section 2 and 3 of the Witchcraft Act, are void for being vague and ambiguous and do not meet the requirements of Article 28, Clause 12 of the Constitution of the Republic of Uganda. 2. As a result of 1 above, the petitioner was not afforded a fair trial as the offense was not known. Article 28, Subclause 12 and 44, Article 11, C of the Constitution were contravened. 3. The exclusion order is unconstitutional because it threatens the petitioner's life by depriving him of means of subsistence and deprives him of access to his property. Hence, it is inhumane and as to threat to life, and contravenes Article 24, Article 44A of the Constitution of the Republic of Uganda. Thus, by depriving the petitioner of access to his property, the exclusion order contravenes Article 26 of the Constitution as well. 4. The petitioner is entitled to immediate release from custody. It is as ordered that the respondent shall pay the cost of the petitioner, dated at Kampala, this day, 20th April 1997, Esti Manyindo, Deputy Chief Justice. Court adjourned.